I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started on this fresh new week, this beautiful new Monday. Got to make sure the tubes are working, and it looks like they are connected. That's tremendous. Let's go ahead and get started then, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I'm a criminal defense attorney, and today we are talking about Trump and disqualification efforts, which are really heating up. They're trying to get him thrown off state ballots all across America, and so I want to go through that story. I've got some good clips on that from the guy who is actually spearheading it, and we're going to go through this in detail because this is something that we spent some time sort of bouncing around last election cycle, going around the various states. And back then, the excuse for adjusting the election, in that case, it was COVID rules, was the pandemic. They were moving deadlines, moving signatures, trying to adjust how the actual elections would be operating. And guys like Mark Elias, who have now founded the Democracy Docket, were behind a lot of that. And there is going to be a new effort in 2024. In this case, though, it's going to be about taking Trump off the ballots, disqualifying him. And we're seeing this happen in Brazil. And we've seen this happen in places like, Russia and China, where they also prosecute their political opponents. And so why wouldn't this happen here as well? There are liberal groups led by this guy. His name is John Bonifaz. He's a lawyer, co-founder, constitutional attorney, he says, and they are making efforts now to remove Trump. I'm going to go through a letter that he sent over to the Nevada Attorney General saying that they've got power to do this and that different states should actually disqualify Trump under the Insurrection Clause. And so I've got several clips there. We're going to go through the letter. We also are going to check in with what's happening with Jack Smith and his prosecution, because apparently one of the secretaries of state, right, these are the people that the left is essentially going to go and flip, is working with Jack Smith. And we'll see if there are other efforts to keep Trump off the ballot. And so there are more rumors that Jack Smith is peering into what happened inside the Oval Office. Remember, he is, I think, right around the corner from some January 6 charges. And so we'll get into all of that right out of the gates. Then I want to turn our attention to the actual case. The Trump prosecution is moving forward. We were expecting some responses today, but the docket was actually a little bit lighter, at least as of 5 minutes ago. And there was, though, an objection. The government is objecting to a continuance. We've got Donald Trump's co-defendant, has filed a motion for a continuance to postpone a SEPA hearing, which is a classified documents hearing, just to make sure everybody's getting their licenses and address any issues there and so on. And so there's a pretrial conference coming up for that. But his lawyer can't make it. He's in trial. So they asked for a continuance of postponement, and the government is objecting, saying, no, sorry, cancel your trial or something. I mean, typical DOJ jerks. But we'll go through all of that because they are objecting. We also are going to take a look at this lawsuit from the Heritage Foundation. This is pretty interesting. Remember that there is this thing called FOIA, the Freedom of Information Act, and it allows different people to request data from our own government. They're supposed to be transparent, and they are supposed to give us some insight into what they're actually doing. But here, they've been covering up the Biden crime family for a long time. And so the Heritage Foundation has actually filed a lawsuit now. And in their lawsuit, they're saying that the DOJ is stonewalling them, and largely to cover this up, right? I mean, it's actually to cover it up. They don't want to give the information out because if they do, it's going to implicate the Biden crime family. And so not only do we have, basically a cover up from the IRS, a cover up from the FBI and the entire Biden administration, we also have, records requests that are covering up for them too. So the Heritage Foundation did file a lawsuit, and we will go through it because there's some fun stuff in there. We also have some reaction from David Weiss. We know him as the whistleblower who is allegedly so-called prosecuting Hunter, as he says. And he responded. He's denying the allegations. Republicans are saying that this guy's basically, involved in the cover-up. Somebody's lying. He is either at the conclusion of his case or he's not. He either had special counsel authority or he didn't. There either was a cover-up or there is or is not. We don't know. But the stories are at odds with one another. We have talked a lot about Gary Shapley's testimony here, and Congress is now digging into this. Chuck Grassley sent a letter to Weiss. Weiss sent a letter back to Lindsey Graham, another senator, and then the Empower Oversight Foundation, which is the organization that represents Gary Shapley, they responded to David Weiss. So we've got a bunch of just crisscrossing letters here. We'll go through them all. James Comer responded to Dr. Gal Luft. Dr. Gal Luft, it's breaking news. We're not going to cover this today, but we'll cover it probably first thing tomorrow. Dr. Gal Luft, it's breaking news. He just got indicted, or has been indicted, but the indictment has been unsealed or released from the DOJ. He said that I think he was already under indictment. And when we talked about him previously, he said, post your stuff on the website. Turns out they actually have posted the stuff on the website. So I believe, actually, let's just segue over there. While we're here, we'll just do a quick update on it, because I believe he just got indicted. Yeah, here it is. This is Gal Luft. U.S. Attorney announces charges against co-director of a think tank for FARA violations. Amazing, just as he said. Gal Luft, dual U.S.-Israeli citizen, allegedly evaded FARA registration. Damian Williams, and where does this come from? Southern District of New York. So it's not a surprise. So last week, if you missed the video, please watch it. Dr. Gal Luft came out, exposed the Biden crime family, and so we turn around on a Monday, and boom, he gets indicted. All right. So they say for years he's engaged in criminal schemes, apparently much worse than Hunter's, because they cared about Hunter's, or cared about his, but not Hunter's. If you have any information about his whereabouts, please contact us. And so here is the indictment. All right, I want to go through this in further detail. We'll save this for tomorrow because it's 58 pages and we've got a full agenda. But we're going to be talking about this because whistleblowers are under attack. They're revealing themselves, and Comer is going to talk about, more whistleblowers means more problems for the whistleblowers. And, Dr. Gal Luft, we talked about it last week. It's like he sort of knew this was coming. We've also got questions. Are they going to bring charges for sharing the Hunter Biden images? The people, retweeting stuff like this woman here in Arizona. AZ Family out of Arizona are saying that they might charge these people with crimes now because everything is fair when you're trying to cover up for the Biden crime family. Then we're going to turn our attention to Jim Jordan. He sent a letter over to this ex-FBI agent. This guy's name is Bradley Benavides, and he used to work on counterintelligence. And they are saying in Congress that these FBI agents literally buried information as the Senate was looking into Hunter. Or in other words, Chuck Grassley and Ron Johnson are digging into this. And when they call the FBI to come in and testify in front of the Senate, the FBI agents show up and they bury the story, in other words. So Jordan is sending a letter demanding answers about this. And then he talks about really how the FBI is covering this whole thing up. And so we've got a lot to get to, my friends. And if you want to be a part of the show, we'd love it if you joined us as a community member. We had a nice, lovely morning stream this morning where we talked about this pretty hilarious story. There's a Democratic socialist mayor out in Georgia who got arrested for burglary and trespass. Which, is that illegal if you're a socialist? And if you're the mayor, don't you own the city? I don't know. That's what we talked about this morning, but pretty hilarious. Burglary and trespass. And my friends, that's happened at watchingthewatchers.locals.com. And so we'd love to have you join us. We generally hit the Trump docket updates when we're not talking about it here. We go through the congressional committee schedules, the Biden schedule. We really pay attention to what our government is doing behind the scenes and take a look at different letters and things. So we'd love it if you joined us. Watchingthewatchers.locals.com, and all of our members get access to our private Telegram group where the chat never, ever ends. It goes on and on, my friends. And so before we get into the news of the day, we got to make sure that we're healthy and fortified, courtesy of our friends at Field of Greens, because we all would like to lose some of those leftover pandemic pounds. It is pool season, if I've ever seen one. But how sick are you of all the ads for weight loss pills and fad diets? We've all been there. We've all done that, and they just don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that, seems pretty obvious. The weight would fall just right off. But look, vegetables, not a fan, and fruit, who's got time to prepare that every day? I don't. It takes a lot of work. Instead, let's talk about Field of Greens. Now, Field of Greens is a science-backed formula, specific fruits and vegetables that you won't find in any other product, because proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, You'll look and you'll feel healthier fast. But the greater proof comes at your next checkup when you walk into your doctor's office and he drops his clipboard. He's like, whoa! Who the heck are you? Well, whatever you're doing, keep it up. You look amazing. And so let's get you started. Go on over to fieldofgreens.com. Enter in code Robert at checkout so you can save that whopping 15% off on your first order. Everything in there, load up your cart. And if you don't want the greens, check it out. There's other stuff for, exercise and weightlifting and sleep and other lean products. And so check them out. Fieldofgreens.com. And don't forget to use code Robert when you check out. All right, my friends. Now, let's get into it because we've got some nefariousness afoot out there. Liberal groups pushing it into overdrive now to get Donald Trump removed from ballots in 2024. And we have been speculating about how this would work for some time here. We know Liz Cheney would be one of the people frothing at the mouth to get this done, saying the insurrection clause of the 14th Amendment might justify the federal Congress to pass a resolution or to do something to disqualify Trump out of the federal election. But now we've got a new interesting theory that is being brought by this guy, John Bonifaz, and others. He's just the co-founder of the Free Speech for the People organization, and they're available at freespeechforpeople.org. He says he's a constitutional attorney, and he, along with some other people with some other organizations, sent a letter over to Nevada asking their attorney general, and really the state-level election boards and the state-level entities, the people who make decisions about who goes on and off a ballot, he's saying, hey, you guys don't have to wait for the feds. You don't have to wait for legislation. You don't even have to wait for Donald Trump to be convicted at all. It's just like your opinion. And the 14th Amendment applies to you. And so if you think Donald Trump committed an insurrection, then you can remove him without anything happening. Like at this moment in time, you have the power to remove him. We're going to listen to several clips from him where he's discussing this. And part of his effort is about putting pressure to bear on secretaries of state, who are in many places, the actual entities that govern the elections. We know that Georgia Secretary of State, Brad Raffensperger, is cooperating with Jack Smith. And so many of these people are going to get a ton of pressure brought down to bear to remove Donald Trump, just like there were pressure on the courts by the secretaries of states and by various lawsuits brought by Democracy Docket or before they were even founded, Mark Elias at a prior law firm, to go and try to change the structure of the election because they don't want to compete in the arena where the votes are counted fairly. They'd rather disqualify their opponents. And now things are heating up. You can see this was the story over from the Hill. They say activists now want to disqualify Trump from the ballot in key states, and they want to do it under the 14th Amendment. They say two civil rights organizations, and we're going to read through a letter from one of them, are launching a campaign to pressure state governments to disqualify Trump from even appearing on the ballots. The groups say that secretaries of states are empowered by the 14th Amendment to bar Trump. Why? J6. It was an insurrection. Two organizations we'll talk about. One is Familia, Vota. The other is Free Speech for the People, and that's the organizer who we'll hear from. They're going to stage protests outside the offices of the secretaries of states in various states, one of which is Georgia, where Brad Raffensperger resides. The groups also sent a letter to the Secretary of State, Cisco Aguilar, calling on him to block Trump. They say that you can use this so-called insurrectionist disqualification clause. Hector from Mi Familia Vota said, we're really focusing on a couple states, Nevada, California, Oregon, Colorado, Georgia, to make sure that they are taking a stand by disqualifying Trump in those spaces. Something the Secretary of State can do. They're calling their efforts called the Trump is disqualified efforts, and they're timing it to coincide with the 155th anniversary of the 14th Amendment. Now, we know secretaries of state, right? State legislatures really, have a lot of the power under the Constitution to create the rules of the elections. But there is a strong trend in this country for the legislatures to just divest themselves of all of the power and give it over to the executive branch, which delegates it to the Secretary of State. Now, we'll go through this in a little bit more detail, but this has happened before, right? This is not a new thing. Like, this isn't a new novel thing that's never happened ever in America. We've talked about this gentleman here, Couy Griffin, New Mexico. He was removed from his position because of January 6th. He was an elected county commissioner. They removed him. Griffin was convicted, lost his job, but the Constitution notes, or they noted before they removed him, that the Constitution doesn't require a criminal conviction. You don't need one. So you can just remove him on your own. They're targeting states that are mostly under Democratic control, okay, like Georgia. Georgia holds a special significance because of Brad Raffensperger. And these are people moving chess pieces around on a board right now. And this is happening well in advance. We are well over a year out, but this is how it started. And I remember this. I remember watching this in 2020, watching all of these lawsuits being filed. And we made little charts and spreadsheets about them back then, keeping track. What's being moved and where. So this is happening now, and I think it's going to actually be a legitimate effort, right? And every time Trump gets indicted again, they're going to say, see, another indictment. See, another indictment. And they're not even going to care about the convictions because they don't care about due process of law. They care about winning. So this guy, we're going to listen to a couple clips from him, and then we will read through the letter. But he is apparently a constitutional attorney, he says. Out of Amherst, Massachusetts, on Twitter, John Bonifaz, the co-founder of Free Speech for People. Free Speech for People, which is an amazing name given the fact that they're trying to remove your speech, which would be the form of voting for a candidate you want to vote for. They'd rather have them disqualified, thereby taking away your right to vote for that person. They'd actually want you to shut up. So I disagree with the name of that. I think it's a bad name, but they're doing it because they're trying to hide the truth of what they're doing. Now, this is John, and he was on with another lefty-ish lawyer who wants to see Trump prosecuted. And he's explaining to us what his interpretation of the Insurrection Clause means.
Section 3 of the 14th Amendment is a critical constitutional provision for protecting our republic. It was part of the 14th Amendment enacted after the Civil War, and it was designed by the framers of the 14th Amendment to protect the republic from then ex-Confederates who were in positions of government power or sought to attain positions of government power. And the view was that they had just engaged in an insurrection in our
a civil
country.
war.
They had taken an oath of office to defend the Constitution. Then they turned around and engaged in civil war. And
there were like several years of bloodshed and death, over the course of years.
They were not able to serve in public office again. And that's what Section 3 of the 14th Amendment says. It says if you've taken an oath of office to defend the Constitution and then you engage in insurrection, you're barred from ever serving in public office again. But importantly, they didn't restrict it solely to the ex-Confederates. They had a debate on that, and they were clear that they were also going to apply it to any future insurrection. And now, for the second time in our nation's history, we've had an insurrection, January 6, 2021, and Section 3 of the 14th Amendment must be applied to anyone who's taken an oath of office and then turned around and engaged in that insurrection.
And so let me read just...
All right, so our second insurrection in America. Wow. All right, so now it sounds like a 4-hour riot is the equivalent that in my opinion was largely allowed and orchestrated by our own government, is now an equivalent to the Civil War. It's like, is this guy hanging out with Joe Biden too much, or Kamala Harris? They think that was literally the greatest attack on our democracy since the Civil War. They've said that many times in many speeches. They're nuts. But I think that's how these people think. Like, the Civil War lasted years, resulted in hundreds of thousands of dead. I mean, it was brutal. A horrific thing. And January 6th is the same as that? Even in the same conversation? It's like a laughable thing. But I think this is really how they think. I think they wake up and they think Trump is going to seize power in this country or something. It's bizarre. So now, though, this is the more important part. Their mental state, set that aside. This is more important. This is where they say how they're going to get this done. What is the mechanism by which they can accomplish this? We were long wondering, is this going to be a judiciary, committee resolution that works its way up and it passes the House? But they don't have control of the House. So it's not going to come from a Republican Congress. And Joe Biden is a disaster, so they can't really rely on him to just beat Trump effectively if Trump is the nominee. They'd rather disqualify him. So how do they do it? If they don't control the House, and if maybe their prosecutions are not going to result in Trump being imprisoned, I mean, they're going at it that way too. How else can they do it? Take him off the ballots.
There's nothing in the language of Section 3 of the 14th Amendment that requires, for example, a prior conviction or even a prior indictment or a tribunal of any kind having to rule before those who are in charge of regulating state ballots enforce Section 3 of the 14th Amendment. So we've been calling on secretaries of state and chief election officials all across the country to apply the mandate of Section 3 of the 14th Amendment based on their own authority to regulate the state ballot. So, for example,
that's it. So in other words, they don't need anybody else to do anything, okay? Only the Secretary of State can just decide. So remember when Katie Hobbs in Arizona was the Secretary of State? She just says, well, I think you committed an insurrection, and therefore you're off the ballot.
Glenn, the Constitution does not allow a 15-year-old to run for president of the United States or to run for Congress, for that matter. And any Secretary of State who received a petition from a candidate of that age, and my daughter's that age, I think she'd be a great candidate, but anyone who received a petition to be on the ballot at that age for that kind of office would be automatically barred based on the Constitution, based on the age qualification.
Yeah, because it says in the Constitution that there's an age limit, and it's really not debatable.
There's also a citizenship qualification. There's a residency qualification.
Right.
And
all mechanical.
Following the 14th Amendment, there's a qualification that you must have not taken an oath of office and then engaged in insurrection if you want to serve in public office. So the enforcement of this really goes.
But isn't there some sort of due process attached to that? I mean, does the founders contemplated that the secretaries of state could just read that uniformly and then on their own disqualify whomever they want? That seems kind of like a bizarre interpretation.
Goes to the secretaries of state and the chief election officials who are in charge of regulating state ballots. It's also true that during the Reconstruction era, when the 14th Amendment had just been enacted, the Justice Department, federal prosecutors were engaged in removing people from public office who were ex-Confederates and based on Section 3 of the 14th Amendment were no longer allowed to stay in office.
Yeah, so the DOJ went and prosecuted anybody who was a Confederate. And they just said, hey, you can't be in an office anymore. You're removed and you're gone now. That was the prosecutors going after their political opponents. At that time, it was enemies of the country. I mean, it was a civil war, right? You were leaving the country. It is a war against the other party. And so he is giving us this example of when the DOJ was prosecuting or using this power to remove people, right? He was literally in a state of war after the Civil War. And now he's not saying it outright because he doesn't have that authority because he's not working at the DOJ. He's just working at a nonprofit, working on the civil side to get Trump removed from the ballots. But you can see here he's intimating that the Department of Justice also has a lot of leeway, man. Maybe they should go remove him too. And guess what? They are. They're prosecuting him. Right? They're coming at this from both sides. One removing him from the ballots, the other prosecuting him with the DOJ.
Justice Department could be doing that again today.
They are.
But that's a separate matter and outside of the hands of a nonprofit to enforce. But certainly secretaries of state have the authority and responsibility, in our view, to enforce this mandate.
Secretaries of state have the responsibility to enforce this mandate. And so let's take a look at the letter now. Now, this one went over to Nevada, and I think that there will be a lot more of these to come. You see, this one got sent to the Secretary of State. His name is Francisco Aguilar. They say, Dear Secretary, in the months leading up to January 6th, they give us the whole rundown, but this comes from Free Speech for the People and Me Familia Vota. And see, it's about 20 pages. We'll fast forward through the highlights. But they say the 14th Amendment to the Constitution makes Trump constitutionally ineligible to appear on any future ballot based on his engagement in the insurrection. So this Secretary of State, I guess, according to the 14th Amendment, is now empowered to be judge, jury, and executioner and just decide on their own whether somebody can run or not. We write to request that you exercise your authority and obligation to exclude Mr. Trump from the ballot. Can you imagine like being on this team, like writing this and just being, I mean, it's like cheating, you know, it's just like, you're just a bunch of cheaters. It's like, yeah, I'll race you to the corner block. And then the kid shows up with a letter and he's like, no, you can't run because you've got the wrong sneakers on. Sorry. You're cheaters, man. The Constitution Insurrectionist Disqualification Clause disqualifies Trump. Why can't you just let the people vote? Here's the last part of the amendment. It says, if no person previously taken oath as an oath to support the Constitution, who shall have engaged in insurrection, vote for office. But Congress may, by a vote of 2/3 of each house, remove such disability. I don't even think this applies to the way he's implying it. But here's his argument. He says states may enforce Section 3 without any new federal legislation. Some law professors explained it. They said states do not need permission from Congress to enforce the Constitution. Nothing in the text or the Reconstruction history suggests that the states need authorization from Congress to implement this. To the contrary, the history of Reconstruction shows that Congress, state courts, and even ex-Confederates all understood to apply without an enforcement statute. So just, you know, one of the things you can do with law, just take it to its logical extension. If you empower the Secretary of State to just unilaterally remove anybody on this basis, they call basically everything is now an insurrection, by the way. We know that, right? January 6th is one they're creating and using for this, but this is a very dangerous thing. I mean, misinformation is now being spread as being a dangerous thing that might cause instability in the country. So then we just have different secretaries of state who can unilaterally decide who runs. They say the two different states have already heard challenges to these, Georgia and New Mexico. And if they start chipping away at this, they'll just start taking those electoral ballots, away from Trump, one after the other. And they don't need many. They say, as Secretary of State, you have the authority to process this. In general, your authority to exclude an ineligible candidate is inherent into the role of your position. The statute governing presidential primary preference elections provides that the Secretary of State shall forward to each county clerk the name of the qualified candidate. So they're referencing law in Nevada to say if it's qualified under your law, and your law says that they're qualified pursuant to the Constitution and the laws of the United States. And the 14th Amendment says he's not qualified. Your law says only qualified can go on your ballots, and he's not qualified. Therefore, you can enforce the federal Constitution. Nevada law leaves you no neutral position. You can't just take no position on this. Nobody else is empowered by law to make this determination. A secretary who sent Trump's name to county clerks would be officially asserting that Trump is qualified, right? They're putting pressure on these people. If you put his name on the ballot, you're verifying that he is qualified. And we're going to hold you accountable for promoting an insurrectionist. Look at this. And your own oath of office, you may not use your official powers to take any action, including approving a ballot placement that would facilitate an insurrectionist's attempt to attain office. The Constitution is the supreme law of the land. You took an oath to support this, and allowing a known insurrectionist to appear on the ballot is inconsistent with your obligation and your oath of office to support the Constitution. And so don't wait for any of this. You've got an obligation to get it done. Look at these letters. It just goes on and on and on. They submitted to him. They say Trump did not attack the Capitol, but neither did Jefferson Davis. As set forth, I have the authority. And they say he's ineligible to appear on the presidential primary ballot in Nevada. So they want him off the presidential primary. 13 pages, and that is pressure coming out from these people at freespeechforpeople.org, going to secretaries of state. That's going to be the attack vector to get Trump removed. And one of the secretaries of state, as we know, is coming under a lot of pressure here out of Georgia. And Jack Smith is investigating him, and it is heating up. Now let's see where the article is. Here it is. It says Trump is facing a nightmare scenario now as top Republicans are cooperating with Jack Smith. We know Rusty Bowers was working with him. Rudy Giuliani talked to him for 8 hours. Bowers said he's hesitant to talk about the details, but he was in there talking about the Oval Office. Here, federal investigators have also gained the cooperation of former top GOP officials, including Bowers and also Brad Raffensperger. Investigators are honing in on incriminating conduct by Trump and phone calls. We know that he called several people, called Rusty Bowers, and he also called Brad Raffensperger. Bowers testified to the J6 committee, and they're really trying to crack the shell of all of his attorneys so that they can get inside and get access to what happened inside the Oval Office. CNN says that special counsel prosecutors want to know more about what happened at the White House, specifically interested in a chaotic Oval Office meeting that took place in the final days of the Trump administration. Apparently, the president considered some of the most desperate proposals, they say, to keep him in power. White House counsel was objecting. CNN got another leak. They just keep leaking. Sources told CNN that investigators have asked several witnesses before the grand jury and during interviews about the meeting, which happened about 6 weeks after Trump lost. Last month, for 2 days, Giuliani sat down with investigators. Prosecutors have inquired about 3 outside Trump advisors who also participated there, including names we recognize: Sidney Powell, Michael Flynn, and Patrick Byrne. Byrne responded, they say, "Hi, Jack Smith. I take all responsibility, best of all, with my eidetic memory. I can tell you amazing detail about it. Parrot-like, say some. Call, collect, I'm here to help." Both Powell and Byrne previously spoke at length under oath about the meeting and other topics, and the special counsel is digging in. During the heated Oval Office meeting in December 2020, outside advisors faced off with top West Wing attorneys over a plan to have the military seize voting machines in crucial states. They also named Powell as special counsel, and they want more information about that as well. Among other witnesses, former National Security Advisor Robert O'Brien. There were screaming matches, and so Jack Smith is going to be digging in on that one as well. But the different lefty groups and their efforts to remove Trump, I think, are just warming up. I think we'll see a lot more of them to come, and they'll be targeting different states, and we'll see. I'm sure there will be another emergency at some point that will be used to justify some more changes in how this country does things. But this one is a very pernicious attack because it doesn't even require, according to them, any due process. Just one simple Secretary of State can say, insurrection. Keep Trump off the ballot. We, of course, will continue to cover this. And thank you for subscribing, my friends, wherever it is you're watching. All right. And so let's continue on with the Trump prosecution. Donald Trump's co-defendant, Walt Nauta, asked for a very simple thing in his case, a continuance. We know that this prosecution against Trump and Nauta involves classified documents. Their teams need to get licenses and get cleared so that they can go see these documents and investigate them. And so they asked for a postponement because Walt's attorney is in trial and the government says no. Sorry, objection. They want a real speedy trial. I think they want to get this thing done before the election so that theoretically they could put Trump in handcuffs. We'll see if that happens. And so any postponements or continuances are just not something that they're going to agree to. But this was what Walt asked for. He said very simply, 6 pages. He said, okay, Your Honor, here is the defendant, Trump's co-defendant, through his lawyer, Stanley Woodward Jr. Hereby request the continuance of the pretrial SEPA conference scheduled for July 14th this week, to a date that's mutually agreeable for all. Trump's lawyers don't oppose this request, but the defense has conferred with the government, and typical, the government opposed this, typical DOJ, and they declined to provide any dates when they would be available for a continued hearing. Now, wait a minute, what? So they give us some backstory here. They say Nauta was indicted despite the fact that the investigation leading to his indictment had long been conducted by a grand jury impaneled in D.C., which is a fun point to put in here. That's gonna come back up, despite the fact, okay, like that's them saying, you know, in other words, this sentence is not really necessary for a continuance motion, but they put it in there because they're irritated about it. And I've been irritated about this too. Remember what has been happening in this case, just to zoom out, catch our breath for a quick minute on this point. They are prosecuting Donald Trump in Florida. See right here, Southern District of Florida. But they did most of their investigating in D.C. because that's where the judges would give them the authority to breach attorney-client privilege and executive privilege. And that's where Woodward and his client were interviewed. I mean, all of this stuff was taking place in DC, but then they used what they got out of there by breaching all of the normal protocols, and they took that evidence and they indicted him in Florida. And they did this sneaky thing in Florida too. Remember when we heard that audio recording that was so damning? It was Trump waving around the documents, and it was going to be the nail in the coffin, and guys like Andrew Weissman were doing backflips and cartwheels before waking up the next morning with a hangover, when they realized that that audio wasn't recorded in Florida. It was recorded in New Jersey. These things matter. These are jurisdictional issues. And so the reason it's important is because maybe the Florida judge wouldn't have allowed the breach of executive privilege or breach of attorney-client privilege. And then the grand jury wouldn't have returned that evidence. So they're bringing it up here, and they're going to bring it back up again. It's just not ready yet, but he's still inserting it right here in this continuance. So he says at all times, and it's just a dishonest thing to do. You know, it's playing in your favorable district and taking those bits and pieces out, and then, you know, and then tactically using them in Florida. Why don't you bring the whole case in Florida if it's such a good case, Jack? At all times relevant to this investigation, Defendant Nauta has been represented by an attorney licensed to practice law in D.C. with little to no notice, right? Nauta got a lawyer in D.C. because the whole thing was taking place there. With little notice to Defendant Nauta, the operative indictment in this matter was returned in this district, and only recently, on Wednesday, July 5th, did Nauta get local counsel, which we covered last week. Now, on Friday, June 23rd, the government filed a motion requesting the court set a Classified Information Procedures Act pretrial conference, a hearing to get together to talk about the procedures. Although government counsel, the prosecutors, they asked whether Nauta's longtime counsel opposed the hearing. We did, and we provided an electronic courtesy copy of the same. The government did not request any dates when defense counsel would be unavailable for such a conference. So this is a scheduling problem, basically. But the government is being shady about it. We oppose your request, and then they just filed one anyways, and the dates got set. So on June 26th, the court entered an order granting the government's request and just set a date for July 14th. At that time, Nauta and his lawyers were not getting copies of the notices, and the government did not advise the lawyer that the pretrial SEPA Classified Procedures Conference had been scheduled. And even when Nauta's team did learn of the conference, Nauta had no ability to formally move the court for relief based on his lawyer's unavailability. It was not until Wednesday, Nauta got a lawyer, and then we could actually file with the court, right? Because you can't just file. You've got to have access to electronic court filing, which is what this ECF stands for. Mr. Nauta respectfully requests the court continue this conference, right? That's all he's saying. Just postpone it a little bit. As the government has long been aware, Mr. Nauta's counsel, they've been long aware of this, all right? They know about this. He's scheduled to begin a bench trial on July 10th, today. Hopefully it went well today. Accordingly, Mr. Woodward will be unable to attend on the 14th. Now, they're going to say, the government's going to come back and say, well, we don't need Mr. Woodward. And they say, yeah, we do. He's our client, and we need him to be here. The government only broadly describes the basis for this conference. Why are we even here for the conference? To establish a discovery and a motion schedule, an order of disclosure, for dates and deadlines and compliances and how this whole disclosure process works. Because they've got 31 classified documents that Trump's team should have the right to inspect and make the argument that's not actually classified. No, that was declassified. No, that's a personal record. Sorry. But defense counsel cannot meaningfully opine on this. What does this even mean? It's not feasible to expect us to agree with the government when we don't even know what they're asking for. So they say, Judge, can we please just continue this, postpone it a little bit? It's not going to be a problem. Therefore, we ask for a continuance. Signed, Stanley Woodward Jr., representing Trump's co-defendant, Walt Nauta, also signed off on by Sasha Dayton, who is the Florida licensed attorney. Pretty simple motion. Lawyers in trial, right? What's the government going to say to this? Do you think that they're going to say, oh, no problem, we'll postpone it a week or something like that? No, of course not. They're the government. Here's what they say. They say, Your Honor, we oppose and we object. They say that defendant Walt Nauta submitted a motion to continue to postpone our court trial, our pretrial proceeding. He seeks the continuance because one of his lawyers is going to be in trial, but he doesn't indicate when Mr. Woodward would be available, nor does he explain why his other lawyer is not capable of handling the procedure. An indefinite continuance is unnecessary, will inject additional delay, and is contrary to the public interest. The government, therefore, opposes this motion. They say that the indictment against Donald Trump is in violation of the Espionage Act. And by virtue of those charges, it's going to involve classified information in this case, both as part of discovery and throughout the trial, obviously. And so this meeting is going to govern how this case proceeds. In order to assist in how CIPA will affect these proceedings, we want to schedule a trial. They say Section 2 pretrial conference in the law is a crucial step in this prosecution. It's going to elucidate the procedures that the parties are going to follow for classified discovery. And I'm very curious about this. I do want to know what the actual process is, because the government is in possession of all of these materials. And as a defense attorney, right, you want to see that stuff. But how long do you get it? Do you have to go over there to see it? What's the jury going to see? What can Trump see? What lawyers can see what? Who can help on it? Almost a month has passed, and there's a strong interest in this conference occurring as originally scheduled. They say his excuses are not needed. First concerns are about his commitments elsewhere. It's a bench trial. But he's got another lawyer, and so the other lawyer should be here. And they say, also he was put in contact with the security group some time ago. And so long story short, they say, Judge, don't move this date at all. Delaying this a number of weeks without any justification is contrary to the public. And so leave it as it is, even though he doesn't even have a lawyer, right? Other guys in trial. So just imagine, just figure out whatever you do in your life, whatever it is. And you have situations like this, okay? You have people that you work with. Hey, can I reschedule that thing next week? I've got a conflict. I've got to be over here. Yeah, no problem at all. Just move it a week, move it a couple days. It's the same thing here, except this is not how the government works, right? People have conflicts. This guy's in trial. It's hard to be in two places at one time, but this is how government prosecutors just are in general. I hate to say it, but it's true. Signed off on here by Jay Bratt. I wish they weren't like this. You don't have to be like this, man. Julie Edelstein and David Harbach. There's a better way to live. Just be a normal human, but they're not. So this other lawyer is literally in trial, and they're like, that's fine, figure it out. All right, So, okay, typical from the government, but they are objecting to this. Now, we are still waiting for Donald Trump and his team to file their response for the trial continuance, because as it stands, we are scheduled for trial in this case in August. And until the court says otherwise, this case is going to go very quickly. And of course, we will continue to cover it as it unfolds. Thank you for subscribing, my friends, as we do. All right. Now, a little bit of a shorter segment, but now let's turn our attention to the Biden crime family a bit, because there's a lot to attend to here. And we know this one. Hunter Biden really wants to get that plea deal done and entered so this whole thing can be put to bed. But there are people who don't want that to happen, because as the days go by, every morning we learn more about the Biden crime family and their attempts to cover up their criminality. But now conservative groups, in particular the Heritage Foundation, are suing the Department of Justice to get access to some of this information about Hunter's criminality. Because if there is a cover-up, if the IRS, the FBI, and Biden's DOJ, which is investigating Hunter, are all involved in trying to sweep this thing under the rug, the more and more information that comes out makes more and more people disgusted, makes more Congress people, House representatives and senators who want answers, and this turns the pressure up. So they're trying to get this thing done. Hunter wants it to go away, but the DOJ is now considering a delay, and that's because there's a lot of pressure coming down to bear. The plea hearing, it could be delayed because the sweetheart deal is now coming under scrutiny. We're going to take a quick look at the judge who is going to be deciding this, and then we'll read through the complaint filed by the Heritage Foundation. But a Delaware judge is set to decide whether to accept Hunter's plea. Coming up soon, July 26. The DOJ is considering delaying the finalized deal amid an outcry that this whole thing is just a slap on the wrist. Big questions about whether Attorney General Merrick Garland lied to America when he testified in Congress. But the judge who's going to be making this decision is this woman here. And let's take a quick look at her. Her name is Maryellen Noreika. She presides over the District of Delaware. And now different agencies, different organizations are suing. So in this case, the Heritage Foundation filed a Freedom of Information Act request. They wanted all of the data between U.S. Prosecutor David Weiss and the Justice Department to investigate this and get to the bottom of it to see whether there really was collusion and a cover-up. And so let's take a look at that lawsuit. We can see here it is 54 pages. This one's being filed out of Washington, D.C., and it is the Heritage Foundation, Mike Howell versus the U.S. Department of Justice. And this is really about a Freedom of Information Act, but it's also a political weapon. I mean, this is going to be used to elucidate the cover-up. It's practicing in the court of law, but it's also practicing in the court of public opinion. And it's a win-win. Let's see what they say. They say the Heritage Foundation is suing the Justice Department. And they bring this act under the Freedom of Information Act. They say that we submitted a request to compel the Department of Justice to make them give us records that we submitted as part of a FOIA request, Freedom of Information Act. They submitted it back in March about the investigation of Robert Hunter Biden by David Weiss and the massive conflict of interest that is at issue here. Joe Biden is the executive of the whole country. He runs the Department of Justice. The Department of Justice is investigating his son. Kind of a conflict of interest there. So when they submitted a FOIA request asking about this U.S. attorney, the Justice Department should have given him that information, right? Specifically, this action from Heritage seeks to compel production of documents related to requests from District of Delaware David C. Weiss. We want to know, because this is their public employees, public record. We submit a FOIA request. We want any emails from David Weiss to the Justice Department headquarters asking about special counsel status. Any emails, send us copies of those. We also want documents related to attempts by Attorney Weiss to bring charges against Hunter in a venue other than Delaware. Because one of the stories was that Weiss, according to Gary Shapley, the whistleblower, Weiss went over to California, talked to the U.S. attorney there, said, can we prosecute Hunty here? She said no, because she had just gotten appointed by Joe. Did the same thing in D.C. went over to Washington, D.C., met with Matthew Graves, said, "Hi, I'd like to prosecute your boss's son in your district. Would you allow me to do that?" He's like, "No." So Heritage wants to know, are there details about this? They say a good deal of the conduct of the state must, by its nature, be secret. Now, that is certainly the case with some aspects of law enforcement, but at the same time, there are events that are so grave, that are so essential to our constitutional order, that if we are to keep our republic, the American people must have a full accounting of the facts. No matter how sensitive, the American people must know. Valid interest in secrecy may well be set aside to some extent by such transparency, but that is the entire point. Secrecy in such cases is to say that all the laws but one to go unexecuted and the government itself go to pieces, lest that one be violated. Saying only via the facts being made fully public can the matter be put as intended to the vicissitudes of political controversy, and the American people exercise their basic and fundamental power to hold the government to account. They say in such a case, transparency cannot be anything but a good for whoever knew truth. He says the American people must know. Now, he gives us some facts here. He says, it is common knowledge that the son of the President of the United States, Robert Biden, has been under investigation by the government for years. Serious felonies, tax evasion, foreign agents, and so on. Joe Biden got sworn in. The public debated whether the Justice Department is going to enforce the law or not. Merrick Garland lied, and I'd say, let me use their language, repeatedly stated under oath that they are being honest. He has repeatedly referenced David Weiss as being appointed by Trump. And for that reason, Garland has resisted repeated calls to investigate Hunter Biden through the appointment of a special counsel. But they say on June 22nd, IRS whistleblowers released 2 contemporaneous memorandum and transcripts. In the interviews, the whistleblowers were not placed under oath, but they were admonished that lying to Congress is a crime. They testified that Weiss sought to charge Hunter with felony tax charges in D.C. and California. But in these cases, both U.S. attorneys, both appointed by Biden, blocked him from doing so. David Weiss is in Delaware. He says, I can't bring charges in Delaware. The crimes didn't happen in Delaware. Hunter was living in D.C. The crimes lived in D.C. Just like Trump can't be charged with classified documents in Idaho, unless he has classified documents in Idaho. They can't charge you for conduct outside of the state. So Weiss goes to California. Hunter committed a bunch of crimes here. Can we charge him in your district? The attorney there was appointed by Joe Biden. She says no. Same story in D.C. Weiss specifically told one of the whistleblowers he sought to bring charges in D.C. but was blocked by Matthew Graves. Weiss stated that the whistleblower that he then requested special counsel authority from Maine Justice but was denied. The meeting was documented. Gary Shapley, he's got evidence of it in emails in writing that he confirmed contemporaneously. Merrick Garland lied to us when he went before Congress, saying it's irreconcilable. So they say Heritage's FOIA's request goes directly to this issue. If the whistleblowers are correct, U.S. Attorney Weiss's office should have responsive records that will corroborate the whistleblowers. Remember, on this channel, we saw the emails that Shapley was sending back and forth. So if we have his side of this, the other side should have been received by David Weiss. And if it's in his public email account, shouldn't those be disclosed via FOIA? If there is some other explanation, the lack of records would give us some answers. They say we need transparency here. Many people say this is a classic sweetheart deal. And more to the point, it would seem to vitiate much, if not all, of the department's need for secrecy. Hunter's lawyer put it, they said the 5-year investigation into Hunter is resolved. They say that this is done. Hunter's people say that this is resolved. And so if this is it, if this is going to be the global resolution, 2 misdemeanors and a diverted felony charge that's going to be dismissed, that's it for that whole laptop, That whole book? Attorney General Garland himself stated he would support a decision by Weiss to testify. But not only does there not appear to be an active investigation, but questions as to the structure abound. Thus, we are reaching the situation where the American people must know, has the Attorney General of the United States misled Congress or worse, perjured himself? Yes. Every time that question has been seriously asked, weeks of public congressional hearings have exhaustively explored underlying issues for the American people. Consider the principles at stake here. No man is above the law. We hear them say that all the time. Maybe they should apply it to their own side. Justice is justly represented blind. They say if whistleblower statements under pain of felony are correct, every one of these fundamental principles is laid low, wasted and desolate. This is why our records are essential, and it's essential that we get them now. And so we see the Heritage Foundation is asking the court to compel the Department of Justice to deliver all of those emails. Order the Department of Justice to do a reasonable search to get them those emails. Do it within 20 days of this court's order and stop them from withholding any of our other requests. We'd like attorney's fees on this one as well, Your Honor. Signed by the Heritage Foundation attorneys. Shout out to Samuel Everett Dewey, Eric Neal, Daniel Mahler, Roman Jankowski, all over at the Heritage Foundation. Doing good work out there. Holding the Department of Justice's feet to the fire with a lawsuit demanding disclosure of David Weiss's emails so we can see who here is lying as Republicans and others try to stop the Hunter Biden sweetheart plea deal from going into effect. Of course, we'll continue to cover this, my friends. Thank you for subscribing wherever it is you're watching. All right. And so we've got some more on this segment. We've got two more segments here. And this one is along the same vein. But now we have reaction. David Weiss, the U.S. attorney prosecuting, allegedly, Hunter Biden, is now responding. Remember that many Republicans have been saying that this guy's lying, or Gary Shapley's lying, or Merrick Garland's lying, because the story surrounding the Hunter Biden investigation just doesn't add up. We're wondering, did David Weiss, this prosecutor, have the authority to bring charges in other states? Did he have the ability to go and get special counsel status? And why was he even asking for special counsel status in the first place? And who does he have to get permission from? And if he has to get permission from anybody, doesn't that mean that that person is really in charge and not David Weiss? In other words, if he's got to go to Merrick Garland, isn't Merrick Garland in charge and not David Weiss? And doesn't that mean that Joe Biden's really in charge and not David Weiss? Yes, the answer is yes. But David Weiss is responding, and he is responding to a lot of people because others are demanding answers. Chuck Grassley sent him a letter, and he responded, and David Weiss responded to Senator Graham. So we've got senators sending letters all over the place. This is what Chuck Grassley sent over to David Weiss. This comes from the Senate. He says, all right, dear attorney David Weiss, Hunter's prosecutor, signed from your friend Chuck Grassley in the Senate. He says, all right, David, based on information that came to my office from individuals aware of the meeting on October 23rd, apparently it goes like this. Justice Department and FBI special agents from the Pittsburgh office, they briefed this U.S. attorney from the Department of Justice, Leslie Wolf. That is one of your top prosecutors. And FBI special agents with respect to the contents of the FD 1023 form that involves Hunter and Joe's bribery scheme. But the meeting did not include any IRS agents. In addition, based on information that I've got in my office, Grassley says, there are potentially hundreds of Justice Department and FBI officials that have had access to the FD 1023 at issue, which begs the question that I've been asking. What steps has the Justice Department and the FBI taken to investigate the allegations? You, the Attorney General, and Director Wray have all failed to answer. This is to David Weiss. David, as you are aware, IRS whistleblowers have affirmed that U.S. Attorney Wolf prevented investigators from seeking information about Joe Biden's involvement in Hunter Biden's criminal arrangements. The DOJ stopped the IRS from investigating. Wolf frustrated investigative efforts to question Rob Walker. Wolf admitted that there was more than enough probable cause to get a search warrant, but she stopped it from happening due to, quote, optics. U.S. Attorney Wolf prevented investigators from searching Hunter Biden's storage unit. And Wolf called Hunter's lawyers, this is the Department of Justice, calling Hunter's lawyers, informing him of the interest in the storage unit. You guys might want to clean that out of all your crack in there. So Grassley says, did Wolf take similar protective measures to frustrate any investigation into the 1023? And so in light of Wolf's questionable conduct and obstructive conduct, during the course of your investigation, Weiss, I'm seeking clarification from you with respect to your knowledge of these allegations and how you handled them. Please answer these questions no later than soon. When did you become aware of the October 2020 briefing provided by the DOJ and the FBI to Wolf and the FBI? Are you aware of any steps that Wolf and Baltimore took to investigate the FD 1023? Why were IRS agents not included in the meeting? Does the scope of your alleged ongoing investigation include bribery and the alleged scheme between the foreign national and Hunter and Joe? And if not, why not? This is a big open question we have. Is this investigation done? Is it coming to a close? Are we anywhere near the end of it? Or is it just getting started? Because if it's just getting started, then we really are premature. Maybe this is the first indictment of 10. I don't think so, though. Everybody is acting like we're done with this, even Hunter's lawyers. And if it's open and ongoing, why don't they just say that? No, this is still an ongoing investigation. This plea deal is just going to be part of the Delaware charges. We've got open investigations into California and DC. We'll let you know. Have you taken any steps to recover the alleged audio recordings that are referenced in the FD 1023? And why were you assured? Why were you assured? When were you assured that you would be granted authority to bring charges in other districts? Have you requested that authority yet? If not, why not? And if so, where was this request made and when was it satisfied? All great questions. We have a lot of it. Thank you for your attention to this important matter. Sincerely, your friend, Chuck Grassley. So that goes over to David Weiss. Now, they're great questions. Part of the problem that we have with this inquiry is we don't know what the status of the investigation is. If it is closed, big problems. But if it's not closed, well, the problems are maybe not that big because there might be more charges coming. We don't know. But they're talking like it is in fact closed. So David Weiss responded to Congress. This time he sent a letter to Lindsey Graham. You know him. This one came from the Department of Justice, from the District of Delaware. The Honorable Lindsey Graham gets the letter. Weiss, the so-called Hunter Biden prosecutor, says the following. Dear Graham, this is in response to a letter you sent me previously. As I recently explained, Lindsey, when I was talking to Jim, since the whistleblower's allegations relate to a criminal investigation that's currently being prosecuted, I have a duty to protect confidential information, all right? And deliberative communications related to the case. And as I likewise indicated, I already told you, I welcome the opportunity to respond to these claims in more detail at some point in the future as authorized by our department. Now, to clarify an apparent misperception, Lindsey, and to avoid future confusion for you, I wish to make one point clear, says David Weiss. In this case, I have not requested special counsel designation. Rather, I had discussions with department officials, regarding potential appointment under the law, which would have allowed me to file charges in a district outside my own without the partnership of a local attorney. But did you do that? I was assured that I would be granted this authority if it proved necessary. All right, so it sounds like you're concluding that it's not necessary given the fact that you haven't pursued it. So, all right, he finishes. And this assurance came months before October 7, 2022, the meeting referenced by the whistleblowers. He says, in this case, I followed the process outlined previously in my letter, and I've never been denied the authority to bring charges in any jurisdiction. Okay. Did you attempt to do it? Did you attempt to bring charges in any other jurisdiction? The answer is no, because if he attempted to, apparently the authority would have been granted and we would have seen charges filed. So then we conclude that he never even attempted to do that. So basically, I think he's saying that the whistleblower is being dishonest about this. He says, your questions about allegations contained in the FD 1023 relate to an ongoing investigation. I can't say anything about that at this time. Sincerely, U.S. Prosecutor David Weiss. So you see here, we're not learning much. I mean, he's confirming a couple things for us. Certainly that he had discussions about all of this, and the FOIA request from other organizations like Heritage might uncover some of this, but it is an interesting response saying, I kind of haven't even asked for it. You guys are saying I didn't have it, or I didn't do the thing. I didn't bring charges, or I was rejected, declined in my efforts to bring charges in other locations, but I never even attempted to do that. Okay, so are you done with this case then? The whistleblowers teams responded. They say, here's the statement from IRS Supervisory Special Agent Gary Shapley's legal team on the David Weiss letter to the Judiciary Committee in the Senate. They posted this. They said U.S. Attorney David Weiss's stories continues to change. As a practical matter, it makes no difference whether Weiss requested special counsel or special authority. Under no circumstance should, quote, the process have included the political appointees of the subject's father because Congress and the public had been assured it would not, but it did. So it's an interesting response, and I think what they're pointing to is there's a difference of perception. David Weiss, we were told through the DOJ, basically could do whatever he wanted, right? There was no roadblock in between him and the pursuing of charges. He could have brought charges in California on his own, didn't need to go through anybody else. Could have brought charges in Delaware, in Delaware, of course, because he's the attorney there, but charges in DC on his own. Nobody would have stopped him. That's not really the case. He kind of did have to get a permission slip from somebody else. And that's the problem. The permission slip all came from Biden people. So of course, they're going to not give him the permission slip. The point in this statement is that it's the permission slip problem that is the problem. Okay, whether he went to go ask for a permission slip or not is really kind of irrelevant. The point is, he's got to go get a permission slip from somebody. And that's the conflict of interest, because everybody to whom he would report to get that is conflicted by virtue of the fact that they work for Joe Biden. And this involves his son. So it's a pretty amazing lack of clarity that we're getting. But there was another good summation on this from our friends on the Oversight Committee, I believe. Here's what they've got. For those keeping score at home, GOP Oversight says, today, U.S. Attorney David Weiss confirmed that there was, in fact, an October 7th meeting. Whistleblower Gary Shapley, his October 7th meeting wrap-up email, says Weiss claimed that he did not have the authority to bring the charges against Hunter. That's what Shapley said. Mr. Shapley's boss confirmed the accuracy of those notes in a follow-up email. We've read through those. But now Weiss is changing his tune about having the authority to bring the charges and is quibbling about what type of authority status he sought instead. David Weiss acknowledged that Gary Shapley is a whistleblower, referenced him. And Weiss also acknowledged that the FD 1023 form alleging that VP Biden and Hunter got $5 million is a part of an ongoing investigation. So these were those two documents. This was the email from Gary Shapley to his boss, Michael Batdorf. Bullet point 2. It says Weiss stated that he's not the deciding person on whether charges are filed. I believe this is a huge problem. It says Weiss requested special counsel authority when it was sent to DC and to DOJ, but they denied his request and they told him, just follow the process, David. In the response, Gary's boss responded, "Thanks, Gary, you covered it all." And this was a whole paragraph in point 2. It's a whole paragraph. So who's lying here? David Weiss or Gary Shapley, who documented the whole thing in writing an email to his boss, who is actually a part of the investigation? Very strange things happening. And Congress is not buying it. Here is what James Comer said in response to Dr. Gal Luft, a whistleblower who is now being prosecuted by the Biden DOJ, and others who are coming forward to reveal more about their crimes.
Guy that popped up out of nowhere.
No, he's very credible, and the people on MSNBC who made fun of me when I said we had an informant that was missing, they should feel like fools right now.
They are fools.
And this is their worst nightmare because, again, this is a credible witness that the FBI flew all the way to Brussels to interview and sent several agents to interview. This is someone that knew about CEFC in detail long before the laptop ever became public. So we feel that this is a very credible witness. We feel that this is someone that we need to talk to in our investigation, someone we will communicate with in our investigation. We're going to request the notes from the FBI meeting from the FBI. That is forthcoming. We want to know why the FBI has never made public this interview. And look, Rob, this is a trend. Rob Walker said he met with the FBI and told them very damaging stuff about Joe Biden and Hunter Biden. We know that Bobulinski met with the FBI and did the same thing. Now we know the computer repair guy did. Now we know the IRS whistleblower did. And now Gal Luft did. But what did the FBI do? You know, our sources in the FBI, the ones that Senator Grassley's worked closely with, say they did nothing. They never investigated any of this. They turned a complete blind eye. And the more bank records we get in, the more depositions we do, the more people that come forward, the more damaging this is for the Biden family.
I don't
bit by
get
bit, it just keeps coming out like drop, drop, drop. Pandora's box gets open, and then we see the dam start to break.
The question we're going to continue to ask the FBI. And look, the CEFC was owned by the Chinese Communist Party. The Bidens took millions of dollars from CEFC. Now think about that. The president of the United States and his family have taken millions of dollars from a company that's 100% wholly owned by the Chinese Communist Party. And they were involved in everything. I've said this in interviews. They weren't just trying to buy American energy. They were trying to buy real estate. They were trying to buy farmland. They were trying to buy interest into defense contractors and manufacturers. This is a bad deal that the Bidens are tied up in. And all the people that were affiliated with the Bidens in this deal have at one point or another spoken to the FBI about it, but yet the FBI never did anything.
Are we going to hear, at what point do we get to hear from Bobulinski in front of Congress, you know, in a prime time setting, you know, where people can actually see it, where it can't be ignored? You know, Rob Walker, these are people that worked. Nobody can dispute that. They worked with the Bidens. They have no reason to lie, and they're telling us what happened here. I mean, Tony Bobulinski has been hiding out for years now. He's been hiding out. This did him no benefit to tell this story. When do we get to hear from these people, and when do we subpoena or get Devin Archer in front? When does that happen?
Very soon. What I wanted to do, Rob, was to get the bank records first, to present the evidence of all the millions of dollars of the Biden family's taken in. Because remember, the press denied that. They said that never happened. They said those were legitimate business deals. They said none of the money ever happened while Joe Biden was vice president. We've proven that to be wrong. They did get money when he was vice president. They have taken millions of dollars, and there are no legitimate businesses. Now we're in the deposition phase, and Devin Archer is supposed to be in front of the Oversight Committee for a deposition next week. Once Devin Archer comes forward and says what he has to say, then you're going to start seeing other people like Bobulinski and Walker and other people come and tell their stories. And I think what you're going to see is there's a consistent pattern here of a narrative that is far different than what Joe Biden's told the American people, and far different than what the pitiful journalists on MSNBC have been saying.
Yeah, James.
I can't wait for these hearings.
Yeah, me too, man. I can't wait either. I'm looking forward to all of those. And so Devin Archer is going to be up on the list. Then one right after the other. We'll see. Now, they are freaked out about this. They are going on full offense. If they're not just charging Dr. Gal Luft, they're going to be threatening other people. This story came from Arizona. It says an Arizona GOP lawmaker may have violated state criminal law by tweeting X-rated pictures of Hunty Poo. You know, those pictures everybody's sharing about crackhead Hunter first son? Wendy Rogers did the old retweet on one of those things. And so now our government here is like, well, maybe she's committed a crime. An Arizona Republican state senator, no stranger to controversy, named Wendy Rogers, sponsored a bill earlier about revenge stuff on the internet. Social media platform that is say it's a problem for kids 13 years of age and up. But she retweeted one of Hunter. And they say, this person says that he thinks Roger violated Arizona's revenge law by retweeting Hunter's laptop. Okay, so they'll prosecute Trump. They're going to prosecute anybody who retweets some bad images. They're prosecuting whistleblowers like Gal Luft. They just want everybody who embarrasses them to be censored and their speech chilled and their lives upended through the threat of or actual criminal prosecution, being audited by the IRS or whatever. They are just out there in full swing. They want to stop anybody who challenges their power. And we are going to follow it to see where it goes. And thank you, my friends, for subscribing, wherever it is you're watching this. All right, and so we've got one final segment on the day before we jump into our comments and your thoughts on the day. But we have more from Congress. Congress and Jim Jordan are now investigating the FBI. Something happened where the Senate was investigating Hunter Biden and the Biden crime family, and they called the FBI in to testify in front of them. But did the FBI tell them the truth, or did the FBI deviate them from their investigation and cover the whole thing up on behalf of the Bidens? Jim Jordan has questions about this guy in particular. His name is Bradley Benavides, ex-FBI counterintelligence. We're going to learn more about him and the letter that Congress sent to him. He's now in private practice. They go work at the FBI, then they get big fat contracts in the private sector. But a little bit more about what happened in this story before we see what Jim Jordan is so upset about. From the Daily Caller, they give us some background on this. They tell us, Jim Jordan is demanding that a former FBI agent sit for a transcribed interview. Who is this guy? Bradley Benavides served as the section chief and deputy assistant director for the counterintelligence division. This guy briefed Republicans Chuck Grassley and Ron Johnson in August 2020. Was anything important happening in 2020 around August? Oh yeah, the election. So Senate is investigating him. They called the FBI in. And in the briefing, there were some things that went awry. Congressional Democrats accused Grassley and Johnson of being conduits for Russian disinformation. Remember this? These liars. Two senators issued reports that highlighted Hunter and Ukraine's business deals, but the Democrats were covering the whole thing up. So that's a little bit more on this guy, Bradley Benavides. Daily Mail tells us that GOP senators who launched the Hunter Biden probe now demand the right to grill the two FBI agents who suggested that the stories were just Russian disinformation. So Benavides came in and told the Senate, no, it's Putin, Russia. Ron Johnson and Chuck Grassley wanted to hear more from him. They sent a letter to him, and they have been looking into his business dealings for some time. All right, so let's see what the letter actually says. This is from Jim Jordan, the Committee on the Judiciary, over in the House of Representatives out of the Congress of the United States. He says, all right, Senior Risk Manager, Mr. Bradley Benavides, guess where he went to work? Amazon. Wonder what he's doing over there. They say, all right, dear Mr. Benavides, the Committee on the Judiciary is continuing to investigate allegations of misconduct at the FBI. You served as the section chief and then deputy assistant director for the Counterintelligence Division from July 2019 until July 2022. We believe that you possess unique information vital to our oversight. And so we ask you to make yourself available to us. They say, previously on August 6, you provided a briefing when you were at the FBI to Senators Chuck Grassley and Ron Johnson that hampered their investigation into Hunter Biden's financial connections. Sounds like this guy obstructed them. They were investigating foreign governments and questionable foreign nationals. As the senators subsequently stated in a letter to you, they said, the unnecessary FBI briefing provided the Democrats, you, and liberal media the vehicle to spread their false narrative that our work advanced Russian disinfo. Okay, so it's amazing. Ron Johnson, Chuck Grassley say we have evidence that the Biden crime family is involved in this massive scheme. They demand the FBI agents come in and give them a briefing. FBI comes in. They say it's Russian disinformation. See, the Democrats say, see, the FBI said it. And just like the FBI created the Christopher Steele dossier, or helped to manufacture that with the help of the Clinton campaign back in 2016, they're doing the very similar thing here. No, it's Russian disinformation this time, except it's true. Last time it wasn't true, they make believe it was true. This time it was true, they made believe it wasn't. So Grassley says, although you stated that the FBI didn't intend to, quote, interfere in our investigation, the practical effect of such an unnecessary briefing that was requested by the Democrats to come in here and the subsequent leaks relating to it created interference which frustrated and obstructed congressional oversight efforts. The FBI is obstructing the Senate intentionally so their candidate wins. Senator Grassley elaborated in testimony before the subcommittee. He explained the briefing was unnecessary and it was completely irrelevant to the substance of our investigation. It was only done because the Democrats wanted it done so they could try and smear us. And the FBI wrongly did their bidding. They're like, sure, we'll show up and say it's Russia. No problem. We love saying it's Russia. We have It's Russia Mondays. The allegations that the FBI arranged a briefing for 2 U.S. senators as a pretext to impede their investigation and then leak that briefing to the media are deeply troubling. It's unbelievable. And then this guy leaves. I'm not going to work with the FBI anymore. Did my job. Goes, gets a nice job at Amazon. The Committee on the Judiciary has oversight. To schedule your interview, please contact us no later than as soon as possible. Sincerely, your friend, Jim Jordan, Chairman on the Judiciary Committee out of the House of Representatives. So Bradley Benavides has gotten a couple letters. He's now in the private sector. We'll see if he responds at all. Some reason I doubt it. But we had one final clip. I thought I had this one from Jim Jordan. Let's see if I have it.
Now let's celebrate the welcome return of Congressman Jim Jordan back.
We're going to jump in with China, and then he's going to segue into the Biden relationship.
You see this type of stuff, whether it's our Secretary of State, Tony Blinken, whether it's our Treasury Secretary, Janet Yellen. This is just how, remember when Blinken first met his Chinese counterpart up in Anchorage, and he lectured Blinken, yelled at him about how we were a bad country, and Blinken just sat there and took it. He didn't push back. There is no way that happens in a Trump administration. So that's the overall problem, is the weakness that, unfortunately, our current commander-in-chief projects to the entire world.
Congressman, what can you tell us about FBI Director Christopher Wray and his testimony that's coming up before your committee on Wednesday? You've got the Durham report, the IRS whistleblower, and now an investigation of cocaine being found at the White House. Well, are we going to get any fresh revelations out of on Wednesday?
Meth.
Well, here's what I know. Time and time again, Chris Wray has told us everything's fine. He even testified in front of Congress a couple years ago, said you can sleep well at night knowing we have fixed the FISA process. Well, really, there are 204,000 reasons why that statement's not true, because that's the number of illegal inquiries they did to the 702 section of the FISA law, illegally scrutinize American citizens 204,000 times, according to the New York Times. So there's a host of problems. We know that the Justice Department has labeled parents as terrorists or simply going to a school board meeting. We know that the Richmond FBI field office said pro-life Catholics were radicals, they were extremists. And then, of course, there's been the retaliation against whistleblowers like Mr. Shapley from the IRS who came forward, and the DOJ kicked him off the case. Or other whistleblowers have come and told us about some of these issues, what they face, like Garrett O'Boyle. So we're going to get into all those issues, and I think a host of others as well. But the main point is there is no way, Stuart, there is no way Republicans in Congress are going to be for reauthorizing FISA in its current form. And that's due at the end of this calendar year. There is no way we're going to do that. We're going to oppose that and a host of other things as well.
Okay, one last one.
All right, so that is Jim Jordan, and we can see that he is staying on it. Christopher Wray, I believe that is on Wednesday. And so we will have the highlights of that testimony on the show as Congress continues to dig into this and more. We'll continue to cover, my friends. Thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one. All right, my friends, that is it for us on the day. We covered some good ground. We got a lot of updates about what's going on with the whistleblower, David Weiss, congressional investigations. We know conservatives are suing to get access to some of the data that the DOJ is covering up and to delay that plea deal. Government's objecting in the Trump prosecution, and a bunch of these lefty groups are trying to get Trump off the ballot using the insurrection clause. And so that is it. But now it is time to hear from you and to see what you have to say about this. And we appreciate all of the amazing support from all of our friends on YouTube and Rumble and locals all across the fruited plain. We had some major gifts coming out. Thank you to our friends. Dolphin Fan is the man in the house, bringing in CS 101, Patriot 1111, Arnett's in the house. What About Me and Captain Flat-tastic, all courtesy of our friend Dolphin Fan is the man on YouTube. Thank you, Dolphin. And Patrick Parker. Hey, thank you, Patrick. Also brought in Dennis Petit, James Hicks, Leslie Bianchi, and Liz Botts, and Steve Lee. And let me take a look. Do I have this properly opened? I do. Okay. So, okay. Patrick Parker. Thank you, Patrick. So brought in Steve Lee, Liz Botts, Leslie B, James Hick, and Dennis Petit. Thank you. And Patrick, another one. Trump and Tucker 2024. Wouldn't be a bad ticket. Hey, Newbie of Death review stuff. Been a member for 15 months, man. Newbie. Wow. That's pretty serious, man. I feel you. Thanks for being here. Says fiduciary. I totally agree with fiduciary. We have another one. 2020-12 Jameson says, I think this is a Section 1983 claim. What were we talking about? So it's like suing the government for your, another one from Jameson, 1983 claims or state version of Bivens claims. So like you can sue the federal government, right, for a breach of your constitutional rights. But I'm just trying to think of what we were. Oh, I know what you're probably talking about. This one, trying to keep Trump off the ballot would be a breach of your constitutional right to vote, I guess, under Section 1983. Yes, I think I understand what you're talking about. Yeah, right, because you have a right to vote. You've got a right to vote for your candidate. And if they're trying to keep him off without due process of law by just declaring him an insurrectionist, yeah, I mean, if they do that, like can you imagine the level of litigation if they just decide to remove Trump? Good questions there from 2012 Jameson. Tony Hay Munkets, a month for 3 months membership. Welcome. Says, I love that you explain stuff to us, but how do we stop it? We all know Trump won this. This has been going on for years. Now we're losing our country. Suggestions. Well, Tony Hay, so it's a complicated question. Generally speaking, I think the way I process this question is I disambiguate, I distinguish between the two entities. I think, America is different than the federal government of America. And as the federal government of America continues to fail, us as Americans will continue to be more free. And I know that sounds like counterintuitive, but think of it the way I think of it is the federal government is like our jailer almost. They keep us suppressed under taxation. They keep us suppressed under inflation. They keep us suppressed under endless wars. They keep us fighting with each other and divided against each other. They're kind of like the jailer. So as the jailer loses power, loses capacity, and people realize that they're not in control as much anymore. They say that they're in control, but people say, we're actually freer than this, and our jailers are unjust. This is not a just jail. Then we get more freedom as they lose capacity to enslave us. So the way I'm personally addressing this is I'm trying to live my best life. I'm trying to elevate all my skill sets, level up my impact on the world, develop my skill stacks, work hard on myself to become a better person, a better man, somebody who can provide more value to my community, to level up myself so that I can be better for my community and for my society, so that I can be a better American, so I can support everybody around me in my life and be contributory. And then that keeps me motivated. And I think that's going to make us resilient. And because, for me personally, because it's more self-reliance. But I think there's going to be a big division between people who think like that and the people who just rely on the federal government like lemmings off a cliff. Like, think about the people who were relying on the $10,000 from the Biden administration on their student loans. There's going to be a lot more of those promises made, promises broken. And if you're in that category, we talk a lot about this on Locals, but if you're in that category, I think that you're going to be a lot disadvantaged, because they're not going to be able to deliver on those promises. And the people who are brought up thinking that the world is out to get them and that the whole society is this very unjust, racist patriarchy run by men, and they just think the whole world is like the people who are living that way, living in a world of negativity, like living in a negative state of mind. I don't think that they're going to have as good of futures as the other people who are doing things to find their purpose, live within their purpose, become a better person, and serve their fellow citizen. I think that is the better path. And if you focus on that, I mean, for me personally, a lot of the negativity that comes down from these tyrants, these little maniacs out there trying to run around and control everything and keep us all depressed and unhealthy and unwell and try to steal our power away from us by acquiescing, giving it up to them, I think that we were able to reclaim some of that, reclaim our individual sovereignty. And so, I don't have a strong suggestion like, hey, if we get a million people to go vote, we can go, like a concrete plan like that. What I defer back to is individual sovereignty, anti-fragility on an individual level, on a family level, community level. And then I think at some point we're going to see a resorting. It's already happening here, Tony. Hey, we've talked about this on our Locals. And we made a video about it here. There's a great resort happening. And two things I think that are important concepts are going to be location and allocation. Location and allocation. Where are you living? And then where are you allocating your TAME, your TAMEE, your time, attention, money, energy, and effort? Where are you allocating those things? If you're allocating your TAME, TAMEE, to old world entities like big government stuff or big woke corporation stuff or all of those things, I would start working on those, reorienting each of those things. Tammy, your time. Can you start moving some time from this world to this world? Start it. Can you move your attention from this world to this world? Can you start moving your money from these entities into this entity? What about your energy and your efforts? How can you take those things and reorient them? And then you'll have this barbell strategy where you'll have some stuff in the old world, some stuff in the new world, and will be a lot more anti-fragile and a lot more capable in the future. Anyways, that's just some random thoughts. Thank you, Tony. Hey, great question. Kaiser of Third Age says, when these politicians say things as January 6th is the second Civil War, where 600,000 deaths, near double the both world wars, I'm baffled. What? It was a lot of dead. Yeah. So maybe you're saying like 600,000 dead Americans. Yeah. Yeah. World War II, I think, arguably was like 60 to 90 million dead, depending on some of the numbers you're looking at. But yeah, it's in the United States, calling January 6th anything other than a riot is nuts. It was like 4 hours. It was not even on a fraction of the cost of the Summer of Love in 2020. And they didn't freak out about that. Instead, Kamala Harris was supporting them getting out of custody. Devin's here. Devin Knox says, so Maxine Waters should never be allowed to run again, right? What about everyone who denied the 2016 election? Right, Devin. It's like two people can play the same game. If you allow them to do it, then I guess all Republican secretaries of state can just disqualify the entire Democratic provision because of insurrection. Yeah, from Devin Knox. Thank you, Devin. Felix says, does anyone else see this as the Democrats having revenge for losing the Civil War to Republicans? And they're using laws made by Republicans to get rid of Republicans. I think you're saying using the 14th Amendment. Well, it's an interesting thing. I've been working on another video, and I've been reading a lot more about the prosecution of political opponents in America. And like Eugene Debs, the socialist who is running from prison, running for president from prison. Yeah, I just think it's, people want to consolidate power, and they'll use whatever tools they have, whether it's McCarthyism or Trumpism, MAGAism, whatever. They'll do it. Good to see you, Felix. 2012 Jameson says, not only Trump, but also any voter. This is slander. Yeah, it definitely seems like it's presumption of guilt. It's a presumption of insurrection based on the mental decision of some Secretary of State. It's totally illogical. Anybody could just do that then. Penny Whitbrock says, eidetic memory is photographic memory. There you go. Nice definition on the word. I didn't know that. Thanks for educating me. Eidetic memory is photographic memory. See if I can remember that one. Thanks, Penny. Says, hey, and thank you so much for reading my request to pop up the spelling of Latin legal terms so we can look them up and learn more about them. I really appreciate that. Which one did we do? Was this one on the Re Ipsa Loquitur? Res Ipsa, the one we did last week? Well, I'm glad we did that. Yeah, Penny, glad we did that. Res Ipsa Loquitur is a good one. It's good to see you, Penny. Penny's over on Rumble, by the way. If you're not subscribed to her channel, you might want to do that. 2012 Jameson says Jack Smith would be a good Bivens claim too. So suing Jack Smith for violating constitutional rights? I'm trying to think how that would work. Yeah, it's an interesting theory. Look, when we live in bizarro world, I think everything's possible. So why not? I like it. Bivens claims for Jack Smith. Fred Pedamonte says, repeat after me. All right, I'll be careful here. What is this? This is from Fred. He says, repeat after me. I, Secretary of State, promise to bar Trump from ever running for office in the United States. So help me God. Congratulations. SKUM. From Fred. it doesn't sound that much different than Letitia Tishy James's campaign, as far as I can tell. Hey, the Chugi Show says good logic seems to think Trump should be able to get this dismissed. When will we see a filing demanding that? So a motion to dismiss, I'm not sure when we'll see it, but it's still pretty early. I mean, we haven't even had pretrial conferences. I think we're still getting disclosures of discovery. So I would imagine after the classified discovery process starts, which I think hasn't even started yet. So they were saying, I mean, we may not even have the SIPA meeting this week. It was supposed to be this week. But a motion, I mean, I don't think that they would want to file a motion to dismiss. Although, you know what? I mean, the trial is in August. So I was going to say we might not see one for a while, but the trial's in August, the Chugi Show. So as of now, I don't know, we'll see it within a month before trial. So it'll be soon. But practically, I honestly think the trial will be postponed majorly. I still have a hard time believing the trial takes place before the election. I really do. But I could be wrong about that. And if the trial gets postponed to after the election, then it's anybody's guess when we see a motion to dismiss, because everything gets rescheduled. But as it stands, I don't know, in the next 2 weeks, as it currently stands, because they've got motions due. Actually, there's an omnibus. Let me give you an exact date on it. Actually, I'll just show you. So there was an omnibus deadline filing that was in Walt's. I think we covered it previously, but I think they told us this. Actually, this was from Trump's trial setting order. So here you go. So here you go. Here's the deadline. July 24th as of now. All pretrial motions and motions in limine must be filed by no later than July 24th as of now. That's for Donald Trump. So that'll be the date. So very soon. Now, again, all of this might move because trial is currently scheduled for August 14th if they postpone that. And like they might not be able to file a motion to dismiss if they haven't reviewed the classified discovery, right? They've got to see something before they can make and take a strong position on what they're up to. Good question. From the Chugi Show. Hey, Carl Burkhalter became a supporter. Welcome, Carl. And Carl, don't forget to grab the Telegram link. If you navigate over on YouTube to the community tab section, then you can grab the Telegram link, and we would love to see you over on Telegram as well. Let's see what else we got in the House. That's from Carl. Carl says, many Confederates served in Congress after the Civil War. Mahone, Hinman, Hampton, Castleman, Chalmers, etc. That's a good fact there too. Thank you, Carl, for that one. Yeah, I didn't know that. But you know what? They're not named Trump though. Okay? So they're allowed. Trump's not. All right. The real J.R. Bond says, Robert, since the 14th Amendment speaks on an insurrection, doesn't this make insurrection and its definition the domain of SCOTUS? I feel like if SCOTUS says J6 was not legally an insurrection, they would save everyone much time and money. It's like they owe it to the U.S. It would be nice to get some clarity on it. And so you're right about this, the real JR. I don't know that we have a good mechanism by which to reach this determination. I was thinking that if, like, say, for example, the Democrats still controlled Congress and Trump was convicted of something, or even not convicted, they could just pass a resolution to say, under the 14th Amendment, as a statement of federal law, Trump has been legally determined to have been but even then, it's sort of like, is that a prosecution by Congress? At some point, the Supreme Court very well may get involved in this, especially if they try to keep him off the ballots. Good to see you, the real JR. Thanks for being here. Adesia says, everyone who doesn't hit the like button is a Fed. It's true. It's true. If you don't hit that like button, you probably work for the FBI. Thank you, Adesia, for reminding everybody. 2012 Jameson says Barr and Durham are deep state. From 2012 Jameson. I think they're both institutionalists who are DOJ lovers and lifers. Indeed. This one looks like this is Joe Biden with spy balloons on his earlobes, which is fun. I think that came in from Geegum Geegum. Says, guide your attention to my China balloon earrings. You will now enter an unconsciousness state of mind. Hunter is the smartest man you know. Do not pay attention to the criminal behavior of the Biden family. On the count of 3, you will now wake up and focus on how the blonde hairs stand up on my legs. Oh, gosh. 1, 2, 3. It's Joe Biden. Termination the pressure. Oh, gosh. Thanks, Geegum, for that one. Salty says, hey, Rob, good logic has the following. Benny has the brigade. I put forth consideration for Robert's rulers or equal justice for all, and that adhere to Robert's rules of order. Well, that's a nice suggestion. Salty Sarge in the House. Robert's rules of order, right? Those are and that's an actual thing. Are you talking about the show? I mean, I think it's it's like watching The Watchers. So maybe it's Watchers. Benny Brigade, good logic following, Robert's rulers. I'll leave it up to you, Salty. I'll leave it up to you in the chat. You guys can decide about that. But thank you for the very nice suggestion. And thanks for the dono here, Salty. Zulu, 17 months, baby. Woo! Woo! Man, that's been a long time. We've been through some serious business, Zulu. I appreciate you being here for all of it. Membership perks. We do try to deliver for our members. I mean, we do member-only streams and posted a bench press video on Sunday. Get your reps going, my friends. Get them up. Thank you, Zulu. Good to have you here for so long, my friend. Keister Bunny, 3 months, Keister Bunny. Welcome. Thank you for being here for 3 months. It's such a funny name, Keister Bunny. Thank you for all you do, Robert. Thank you, Keister. And you've got the bunny eggs, bunny ears in your in your profile. And thank you, Keister. We had this one from Daniel Henry. Says, don't know if this has been mentioned yet, but the president is not, quote, an officer of the United States, constitutionally speaking. Officers are appointed. Presidents are elected. See U.S. versus Moot, 1888. I've been reading a lot about this too, Daniel Henry. And where did I get this? Oh, you know what I got this from is from the Constitution. I agree with your point. So from the Constitution, Article 2, Section 2, Clause 1, it says that the president may require the opinion, one singular, in writing from his, I forget what the term is, from his departments, I think is the term. The reason they put it that way is because the president is not an officer. The president may require from his departments, right? There's a hierarchy there. And that power, the opinion in writing power, is nestled right in between the pardon power and the commander-in-chief power, both of which are exclusive only to the president. So the president is not an officer, and the president is the root power. I mean, I've made this argument before, and I had to check myself. The president is not subject to, I would say, NARA, okay? Because NARA is a department under the executive branch. And if you read the Constitution, in particular, the opinion clause, which doesn't get a lot of conversation, but which I think exonerates Trump, is the thing that puts him as the root power. And there's no other position. So to subordinate the president to a criminal act of Congress, or to subordinate the president, in this case, over classified documents, or to subordinate the president to the Presidential Records Act, which is not a constitutional amendment, it's just a statute, is constitutionally unsound, and Trump is exonerated. Good to see you, Daniel. Says, referencing my last super chat, Amendment 14, Section 3 does not ever enumerate the president as subject to disqualification. That's true too. That's true too, right? It's a very ambiguous phrase, which is why we were concerned about how this would be implemented. And apparently they're just saying that a Secretary of State can just unilaterally make the decision on their own, which is nuts. It's like, what kind of order is that? And they're calling everything an insurrection now. So some great comments there from Daniel Henry. Good stuff there. You know your law, my friend. I love that. Good to see you. We had this one from Geegum Geegum. Says, allocating my Tammy to smashing the Watching the Watchers like button, baby. Thank you, Geegum. And this is, oh, it's not emoji. I have that here. I have the like button in GIF form. I'm pretty sure. See how fast I can get this. We have so many good memes. I can't even keep track of them all. Here it is. That's that like button, baby. Don't forget to smash that like button. The Watching the Watchers like button. And thank you, Jigam, for that one. Daniel says, furthermore, anytime a clause applies to both the president and the officers of the United States, the Constitution consistently identifies them both. Yeah. Yeah, and I would agree with that. And I would also say that the Constitution kind of also disambiguates between the president as a person and the office of the president, right? So then we ask ourselves, because then we're getting into who is the actual owner of the opinion. And is it the office of the presidency or is it the actual president? I think it's the latter, but it's a fun argument, and it's really good to see that. So Daniel, I'd be curious what you think about that. You know, if you dive into Article 2, the opinion clause, I read it as it applies to the president, the person, and that Trump is entitled to those documents. Pickle jars for Hillary. Can she open those like with a cloth or something? Says stop Trump from running to preserve democracy. I know, shatter democracy to preserve it. Sounds like a good Democratic plan. Joel Flint says, can the people sue these people for attempting to remove an electoral candidate? Yeah, I would think you could probably, sue the Secretary of State and say they're violating your rights, right? Just like the Bivens claim, like Section 1983 claims. These are my rights are being violated lawsuits. And thanks, Joel, for being here. First super chat on the channel, Joel Flint in the house. Yeah, I think you'll probably see like parties respond or attorneys generals respond. So like if a Secretary of State, I fully expect to see battles on this. I mean, I think we're going to get there. For those of you with us in 2020, we had a whole chart. We were following different lawsuits in Pennsylvania and Georgia and Wisconsin and Michigan. Just like we cover various suits here, or various cases here, we were covering all of these election cases. And they started way soon. I mean, they started way before the election. And guess what? It worked. So they're going to do it again. I have no doubt. Good to see you, Joel. Salty Sarge says, hey, for Tony Hay Munkets, do not go gently into that good night. Stand fast and be heard. Good comment on that. Yeah, I mean, the alternative is to just lay down and die. So what are we going to do? We got to stay positive. We got to take care of our body, minds, and spirits and souls, and help our fellow men and women, and persevere, baby. And they're going to lose, man. They're going to lose. Look at them. They were talking today about how fitness is a right-wing thing. Did you see that? So, so that's okay. So they're just going to be all right. They're not going to have much to really be proud of other than just, I guess, molding into the couches. All the right-wingers will be getting their exercise in, and all the left-wingers will be debating their pronouns in their crumbling cities with their feed bags. All right, and that's why we're going to win. All right, a bad poet says, Bizarro world is 180 degrees. So seditious conspiracy applies to the speakers, probably to Jack too. Good to see you. Good to see you, a bad poet. Bizarro world is 180 degrees. Indeed it is. And it feels like we're living in it. Jameson's here, says Counterman versus Colorado is another case to look at for the Jan Day issue. Look at that case. The FBI can now be hit with DNC as potential coup. I'd love to see somebody sue the FBI for a coup. That would be a great lawsuit. Oh man, that sounds like a fun one. All right, good to see you, 2012 Jameson in the house. Thanks for the donos today. Hey, Walters. Thank you, Walters. No question on this one, but very nice, Walters. Thanks for sending that one in. This one came in from Daniel Henry. Says the only official process that has thus far transpired to determine whether Trump was guilty of insurrection was the second impeachment trial. Although the Senate is not a court, Trump was acquitted. Yeah, another good point, Daniel. Yeah, great points. And I think, that's the kind of stuff that I was waiting for to anchor in some sort of decision point on this, Or I was thinking, I am not writing off GOP shenanigans or something. I could easily see a narrative shift at some point, or an attempt. Trump gets indicted 4 times. You get a bunch of people, finally saying, oh my gosh, enough's enough. Like, I can envision this. Enough's enough. I stood by Trump from the first 2 indictments, but after we learned what came out in this January 6th case, I can't do it anymore. And so now I'm leaving, and now I'm leaving, and now I'm leaving. And that would cause Congress to come together and pass a resolution, and then that would enter at a federal level, and then the states would take the guidance from the feds and then not put him on the ballots or something like that. I was envisioning that. But they don't have the control of the House, and I can't imagine a world at this point now where the Senate and the House agree on something like that. I don't think it would ever happen. So now their only alternative is to go to the secretaries of state, which is why they're going to the friendly states. They're not asking Texas to do this. They're going to go to California. They're going to go to Georgia. They're going to go and try to peel them off one at a time. But then I was thinking, okay, then the other alternative is they try to get him convicted before the election. So the conviction itself in anything could be used as a disqualifier. Let's say he's convicted. Well, but even as a felon, you can run. But then that would justify, a conviction would justify some sort of resolution elsewhere. In other words, the conviction doesn't disqualify him, but it justifies a House resolution or something. That causes the floodgates to open up. But honestly, I don't see that path happening at all anymore, which is why they're just trying to bypass the whole system and go to the SOSs, which is just reprehensible. I mean, it's really like, what kind of people are these people? Good to see you, Daniel. Thank you for those. The Real JR says, thanks for the answer. Under what kind of action would that challenge look? Isn't it just a declaratory judgment? Let me go back up and check what our conversation was about. Says, I was asking if SCOTUS, what kind of claim would it be? So, okay, yeah, it's a great question. So how would a Trump case end up in front of the Supreme Court? Let's take this Nevada example and just play that out a little bit. All right, let's say they send a letter to the Secretary of State. The Secretary of State removes Trump from the president, from the primary ballot. Trump files a lawsuit for an injunction, right? Trump files a complaint against the Nevada Secretary of State for probably just a standard kind of elections claim under state law, and say that he was unjustly removed without due process of law. See what those courts do with it. If Trump loses, it gets appealed. If Trump wins, his name's back on the ballot. So it'd have to be something like that. And you'd have to get over the hurdle of some Secretary of State taking his name off the ballot in the first place, which I think is going to be a big hurdle. Like, that's going to be a big ask to ask for somebody to do that. But if they did, then Trump would have actual injury. Okay, he would have standing because he's being harmed. He's running. He's already filed to run. So then he would file a complaint. If he lost, it'd work its way up to the Supreme Court. If not, it would be dealt with at the lower level. Good question. This one from Voice of the People says, does Brad want civil war? Because that's how you start a civil war. Seriously, this sets a bad precedent for future removals from ballots. Yeah, I think you're talking about this Bonifaz. If you start pulling people off of ballots, I mean, yeah, could you imagine what that would do? People, I think, would be very upset about that. I would be very upset about that. We could just vote for Trump. If we think Trump is an insurrectionist, we can just vote against him. If we think he's not an insurrectionist, and we think that the other side and the other people who claim he is are a little bit nuts, then we can vote for him. It's our decision. Just put his name on the ballot. What are you so afraid of? But they are afraid of losing because their candidate is barely alive. And so unless they do something with Joe, this is the strategy. This is the campaign. Unless they do the old Newsom switcheroo on him, then this is what they've got. So yeah, it sets a bad precedent, and it's going to cause, the further decay of America, but I don't think they really care about any of that. at all. Thank you, Voice. Good to see you, Voice. Voice is always joining us on our morning streams. We love you, Voice. 2012 says Counterman versus Colorado, page 13 on the incitement issue. Man, you're giving me some good homework, 2012, Jameson. That sounds like another good one. I'm very much looking forward to Trump's team and their responses to a lot of this, and maybe we'll get into some of that tomorrow if the dockets are fresh. Former says, I don't remember how long ago I found you, but it was before Floyd. Wow, Former. Yeah, so Floyd was 2020, right? It was like May 2020, I believe. It's been a long time, Former. We're glad you're here, brother. Thanks for being here. Former LEO in the house. Walters. Thank you, Walters. This one came in from Walters. No question, but another one. Thank you very much, Walters, for being here and supporting the donos with the donos today. Jameson says, the indictment also says Trump violated the executive order, not the law. I did see that. You're right. It does reference the executive order. Yeah, anything other than the Constitution is subordinate to the Constitution. So if Trump has power under the opinion clause to take these writings, they're his. That's my argument. Daniel Henry says Congress has the impeachment power to check the president, and he has the veto power to check them. Subordinating him to their preferred method of communication makes the checks unbalanced, supposed to be equal branches. Brilliant. From Daniel Henry. Yeah, and it's exactly right. And Daniel, when I was reading into this, it's like a perfect series of comments today because I was just digging into this. I found a quote from some Judiciary Committee hearing here, I think I actually have it. Let me see if I can grab this real quick. Yes. So this is from a law review article, which is great. I mean, if you want to, you can find this one. Some opinions on the opinion clause. I'm working on a video on this one. But, okay. So here you go. The House Judiciary Committee put in this point in 1879. Okay, the House Judiciary Committee. 1879. Here's what they said. The executive, meaning the presidency, is as independent of either house of Congress as either house of Congress is independent of him. And they, Congress, cannot call for the records of his actions or the action of his officers against his consent any more than he can call for any of the journals or records of the House or Senate. Okay? Congress can't demand the House and the Senate give them their records, and the Senate and the House can't demand that the president give him their records. It's only fair. It's exactly what Daniel Henry is articulating here. The powers of one branch against another branch were thought about at length. And they fought about them in Federalist and Anti-Federalist papers for a long time until they got to a conclusion and synthesized them. So when Congress just says, now we're going to pass the Presidential Records Act, and we're going to now say that we can mandate that you give your own documents to the National Archives and do this and do this and do this because we're Congress and national security and all this crap. No. Sorry. The fact that other presidents have complied with that in the past and nicely turned their documents back over is a nice thing. Trump didn't do that. Guess what? He's not required to do that because they're his documents. So great stuff there. And another great comment from Daniel Henry. Hey, Bara's in the house, says new subscriber. Thanks, Bara. Thank you for subscribing. That's great. You know, I was looking at our analytics on YouTube. 50% of the people who watch on YouTube are not subscribed. 50%. It's like amazing. I'm like, it's kind of sad, you know, kind of, oh, my heart. 50%? Oh, man. Come on, man. All right. So thanks, Bara, for subscribing and joining us on YouTube. And we're grateful for that. Let's say hello to our friends on Twitter before we wrap it up and go over to our locals members only after party, baby. Who's watching on Twitter? We got 5 people today. Whoa, boy, it's crazy over here on Twitter. Wow, that's out of control. All right. Danny McWilliams is in the house. Jeff Bishop says Robert rulers are just and fair. I like that. Cheryl Orlowski says, Robert, you do a great job at breaking things down, but I can't watch today. My head is exploding. I can feel you on that one. All right. Well, don't explode your head. All right. Put some ice packs on there. Take 2 Advil. We'll see you back in the morning. All right. Feline Fun says, if they take Trump off the ballot, can his voters just write his name in? Yeah, they could. And but he would lose. Isn't it ultimately the voters who determine who is qualified to lead them? Wouldn't that be nice, Feline Fun? That was my thought, but apparently that's not what that so-called constitutional lawyer thinks for some reason. Danny McWilliams says most of the countries still haven't paid us back for World War something. And Deplorable says, so Jay Bratt, who put Nauta in the situation and was threatening his lawyer, doesn't want to wait a week? Doesn't want to wait at all. Danny says it's we the people, not we the Democrats. And those were some of our friends on Twitter. Yeah, this one came in from Newsmind, says charges just filed against Gal Luft. Yeah, I mentioned that right at the start of the show. It's a big indictment, so I will go through that in tonight. We'll probably go through that in full tomorrow. I just want to detail it up a little bit. I also want to say what's up to Debbie Lau. Says, so what happens when Trump wins? The write-in vote. I don't know. I think it's hard to win a write-in vote. Jeff says, we love the watchers, but now it's time to make some rulings and fill the prisons with convictions. Art says, proceeding against Trump regarding January 6th would be double jeopardy. Well, I don't think they've charged him yet on that. They just they impeached him, which is a whole separate deal. But, all right, my friends, that was from our friends on Twitter. We had a bad poet with another super chat. Thank you, a bad poet. Says Trump would make a good board game. He's making cards. Why not a fun game? Imagine the cards. You're being sued. Go back 3 squares. I think it could be a fun game, actually. You're being sued. Go back 3 squares. Go to jail. Do not pass go. All the things. All right, so that's from a bad poet. And thank you, my friends, for those amazing super chats and donos. Your generosity really is appreciated. But that is it for us on the day. And let's go and say goodbyes before we wrap it up and head on over to our after party. We're going to watchingthewatchers.locals.com. We would love it if you joined us. We have a great community. We do member-only morning streams. We post some fun stuff from time to time. We'd love it if you connected with us. watchingthewatchers.locals.com. We do the Trump daily updates on the docket. We hit the congressional committee schedules, and we do other fun stuff. We also want to invite you to check out fieldofgreens.com, where you can save 15% off with the code Robert at checkout. A lot of good stuff. I know sometimes it maybe doesn't sound ideal to, eat a green product like that. I'm just telling you, take a look at the ingredients on the back of the list. Try it, see what you think. I think you'll enjoy it. If you like this mind map and you want to use this type of software, you can. Free account you can create at spotlightlawyer.com/mindmaps. You can try it out at your heart's leisure. I want to thank our mods and meme smiths on the day. Big shout out to Donut Mind Me, who is clipping hard for us. Thank you, Donut Mind Me. I appreciate you today, my friend. Great job. Also, shout outs to Dog Digger, Janek909, our friend John Allen, Zach Nichols, Beyond Geostars, Zulu's in the house, Ronnie Cole, Playin' Hooky, Just Cause, K-Bean, and our friend Vienticus Prime. Also, shout outs to Geegum Geegum, our meme smith extraordinaire. Shout outs to Sleepy Dog Lee, Nathan, and 810 in the house. And that, my friends, is it on the day. Thanks to everybody who made the show possible and everybody who joined us on this beautiful Monday. It is going to be a busy, busy week, my friends. We've got, at least on Wednesday, we've got Christopher Wray testifying in front of Congress. We've got all sorts of deadlines in the Trump case. We're waiting for his response on his continuance. We just had Gal Luft just get indicted by the DOJ. And so we're going to be back this week every day right here to cover it. And I hope you join us so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Jameson Lee says, who was the female prosecutor that had a demotion? That was... I know who you're talking about. I don't think that was Leslie Wolf. Was that Julie Edelstein? I think it might have been... I'm not sure. Good question, 2012 Jameson. I think it's one of the Trump prosecutors, though. Having a hard time remembering the name. But I'll try to dig into it. Jameson, thanks for the final super chat. That, my friends, is it for us on the day. Locals, hang tight. We'll see you in a few quick seconds. Everybody else, make it a great night. I'll see you right back here in the morning, in the evening. Bye-bye, everybody.